Our next session will take an inside look at applications for expedited procedure and the Secretariat's role in managing abbreviated timelines from SIAC Secretariat's perspective. On this panel are Mr. Kevin Nash, Deputy Registrar and Center Director of SIAC, and Ms. Lim Shijin, Counsel of SIAC. Moderating the session is Mr. Kronenburg. Mr. Kronenburg, please.
Thank you very much, Sue-Ann. Unfortunately, I'm still here. You're going to be seeing a little bit more of me this morning. I'm very pleased to be having this discussion with Shijin and Kevin. So, you know, a lot can be said about expedited procedure from the standpoint of the tribunal, of counsel, of the parties. But this next segment is to give everyone a look inside the apparent black box. What happens on the other side of the curtain in SIAC. And hopefully this will give everyone a little bit more of an insight as to how expedited procedure applications are processed, evaluated, the thinking behind granting expedited procedure arbitrations. So if I could just get into the questions. And this very first question is posed to Kevin. Apart from the grounds stated in Rule 5.1 and the factors mentioned in Rule 5.2 of the SIAC rules, which are the views of the parties and the circumstances of the case, what would the President take into account in determining whether the case should be conducted in accordance with the expedited procedure?
Thanks, Edmund. Maybe the best way to start is to look at the grounds for application really as threshold requirements. So a party can apply on the basis that the amount in dispute is under 6 million on the basis of party agreement or in cases of exceptional urgency. So that gets you into the channel. But then, of course, we're going to look at the actual nature of the dispute. The interesting thing about the construction of the SIAC expedited procedure is that it's in the main body of the rules. So it's not like some other institutional rules where there's a separate set of rules or it's automatic application. And because of this, a lot of applications are contested. So let's leave aside party agreement for the moment. So you're having applications on the basis that the amount in dispute is under 6 million Singapore dollars or in cases of exceptional urgency. So what are we looking at? It's a contested dispute. What we often see is the moving party will say, this is a very simple dispute. It should go under expedited procedure. The party opposing the application will say, no, 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 it's very complicated. We're going to need fact witnesses, expert witnesses. We're having trouble instructing counsel. And then the institution is called upon to determine whether this should go under the expedited procedure. So we're going to be looking at, as a first port of call, what does the arbitration clause provide for? Is it a sole arbitrator or a 3-member tribunal? Are we going to be appointing a sole arbitrator, notwithstanding the language in the clause? What is the urgency and time sensitivity of the dispute? How long is the claimant waited to bring this case? Are there going to be due process considerations? Can it be done in 6 months? Are there any jurisdictional questions? Has the respondent raised the specter of a jurisdictional issue? Can that be dealt with as a preliminary question, or is it intertwined with the merits? And the overall complexity. Are there complex issues of fact and law? Have the damages crystallized? It could be the case that a party has applied on the basis that the amount in dispute is currently under 6 million. But then when we look at the papers, it seems like this dispute is going to get a lot bigger and a lot more complicated. We will also look at elements such as the need for witnesses, both fact witnesses and expert witnesses. Are the documents in multiple languages? And what is the eventual place of enforcement? One thing that's interesting for us is that we can perhaps identify maybe where enforcement will take place, but enforcement could take anywhere, or could take place anywhere. It could be that you had, say, a Vietnamese respondent, but there are assets in the UK. So effectively, we are looking at the due process considerations. Can this be fairly adjudicated within 6 months?
Thanks, Kevin. Let's get on to this 6 million Singapore dollar cap under Rule 5.1A of the SIAC rules. How in practice is this calculated? For example, if you're using foreign currency, what's the date of exchange? And what does this really mean? Do you lump in the claim, the counterclaim into the $6 million figure? Yes. all these questions, I'm sure a lot of people want answers to them, so I'm going to have to give this to Jean.
Okay, thanks, Edmund. So as the total sum in dispute actually consists of the claim, the counterclaim, and any defense set off, we usually look to the documents that the claim and counterclaim sums are contained in to determine the relevancy, the relevant currency conversion date. Therefore, it would be the date of those documents that would be relevant for our purposes. Yeah. Okay,
so you use the date based on the documents,
yes.
And it's going to be the claim, the counterclaim, and any defensive set off, I guess, as well. Okay. Let's say I am the claimant. I have actually a claim for 7 million, but I want to go under the EP. Can I say I'm going to forgo that 1 million and go under the expedited procedure?
Yes, the claimant can choose to do that, whether for technical reasons or because it genuinely wants to waive its claim. However, if it's evident that the claimant initially claimed for a high amount but only reduced it for the purposes of bringing itself within the $6 million threshold, this will also be taken into consideration. Also, if the matter gets accepted and the claimant subsequently reintroduces the claim amount, this may result in a couple of scenarios which might defeat the point of taking out the EP application in the very first place. So for example, parties or tribunals requesting for multiple extensions of time for the tribunal to make the final EP award, and the possibility of costs being ordered against the claimant. And also, Rule 5.4d provides that any party can apply to take the matter out of the EP proceedings. The respondent may then raise any reintroduction of claim as a point against the claimant.
Thank you, Jean. What about exceptional urgency? What does this really mean? What would be some examples of exceptional urgency that the SIAC might consider?
So in one successful matter, the claimant alleged that it faced difficulties in completing its shipbuilding contracts in time, and consequently, the claimant was put on risk of being liable to its own clients for substantial damages for non-performance as a result of the respondents locking the claimant out of the tenanted premises despite being aware that the claimant was carrying out the business of shipbuilding on the premises. So in that case, it was accepted on the grounds of exceptional urgency. Another matter that was accepted under Rule 5.1c involved a sale and purchase contract for iron ore, where the claimant argued that the respondent's financial status was precarious and the respondent was taking steps to dispose of his assets in India. The respondent had been sued by its creditor in the Indian courts. The respondent was also involved in proceedings in India, where a third party was actually claiming competing rights over the iron ore that the respondent was supposed to deliver to the claimant. Iron ore mining also had been banned in certain parts of India, the result of which was that the price of iron ore kept fluctuating, and therefore that made it necessary for the parties' rights over the iron ore to be determined expeditiously. So all in all, it was just imperative that the arbitration was to be completed expeditiously so that the iron ore cargo did not deteriorate in value. So in yet another matter where Rule 5.1c was actually accepted, the claimant argued that there was exceptional urgency as there was a risk of dissipation of the cost of adjudication previously awarded in favor of the respondent. As of the date of the claimant's EP application, the court had yet to dispose of the claimant's application for a stay of execution of the sums awarded to the respondent, but the court also accepted that the documents submitted by the respondent to prove that it was a going concern was questionable. Thus, it was in the context of the above court application that the claimant submitted that an earlier disposal of the arbitration would render the claimant's court action for a stay of the execution of the sums awarded to the respondent and the risk of dissipation of monies paid prematurely to the respondent nugatory. We also caveat that consideration has to be given to the nature of the respondent's objections as well. Yeah.
Thank you, Jean, for that very, very comprehensive answer. Let's get on to abbreviation of time limits. Now, 5.2 says the registrar may abbreviate any time limits under these rules. If I could just ask Kevin, what would the SIAC take into account in abbreviating time limits, and what time limits are we talking about here?
Edmund, this is actually one of the very good things about having a session like this, because this rule is very rarely invoked. Now having 600 applications, I've only seen a few times where a party has actually requested for an abbreviation of the timelines. The most common scenario would be when an application is made under exceptional urgency and there is urgency to the request. rather than having the 14-day timeline for the response, it could be the case that we might decide to abbreviate the timeline for the response. Naturally, we want to have the respondent's comments on the expedited procedure application, but we could abbreviate that timeline. Technically, by a strict reading of the rules, the 6-month timeline for the award to be rendered could also be abbreviated. So this is an application that could be used. One thing that's important to remember is after the application for expedited procedure, assuming that we are going to appoint a sole arbitrator, is Rule 10.2 provides that SIAC can proceed with the appointment at any time a party requests. So regularly, it's a 21-day timeline, but if it was quite urgent, a party could make an application for expedited procedure. We work very expeditiously to get the application decided, and then that party can say, we are not going to agree on a sole arbitrator. Please, SIAC, appoint the sole arbitrator with the greatest possible haste. Under those circumstances, with an abbreviated response, the application dealt with quickly, and then no agreement on a sole arbitrator, from the time of the filing of the notice to the appointment of the sole arbitrator can be very quick. So this is a feature and a tool that parties should think about when they're filing an application for expedited procedure, particularly if the ground of exceptional urgency is invoked. And actually, Edmund, for good order, I should add one institutional trick that we have, and one thing that you always want to be careful with, is that we're not disturbing timelines in the clause. So if there are any preconditions, timelines for nominations, that's not something that the registrar has the authority to go over and above. These are timelines under the rules rather than timelines in the clause.
Thank you, Kevin. Yeah, that raises another question in relation to the appointment of a sole arbitrator and the expedited procedure. So that's 5.2b. The case shall be referred to a sole arbitrator unless the president determines otherwise. So there's a possibility for the president to appoint 3 arbitrators if, for example, the clause provides for that. What does the SIAC take into account in deciding whether to go ahead with the sole arbitrator or to stick with, let's say, 3 arbitrators under the clause? And I know there's a case in China related to this. So could you tell us about this?
Yeah, so the default is that the president can or is to appoint a sole arbitrator, but there's also the flexibility to appoint a 3-member tribunal. We have had cases under the expedited procedure where the arbitration clause provides for a 3-member tribunal, and we have in fact decided to appoint a 3-member tribunal under the expedited procedure, and we've got these done in 6 months. But you also have to consider if you have an arbitrator, a 3-member tribunal, 1 resident in Vancouver, 1 in Ho Chi Minh City, and 1 in Sydney, if there is going to be an in-person hearing back in the previous normal, that this is going to be difficult to get done in 6 months. And then from a financial perspective, often parties are choosing the expedited procedure because of the saving on costs. So you're going to be paying three much as much on arbitrator fees as you would for a sole arbitrator tribunal. What we would look at when we're deciding if the arbitration clause provides for a 3-member tribunal and the default is a sole arbitrator under the rules, has the claimant conditioned its application? Has the claimant said, we want the expedited procedure, but only if it's before a 3-member tribunal? This very rarely happens, but it's open for the moving party to say, this is the nature of our application. We only want this, thinking about the eventual place of enforcement. But this goes to a bigger issue as well on an express term versus an incorporated term. So Edmund, the case that you were talking about, of course, Noble Resources in Shanghai, that's a case where an SIAC award was not enforced. I think it's important for me to note that we have had that same scenario in a case in Ningbo where the award was enforced. But basically, the read that we have at SIAC is if it's 3-member in the clause, the parties have agreed to a 3-member tribunal under the regular procedure, but they've also agreed to the president's discretion to appoint a sole arbitrator in cases where it's the expedited procedure. There are competing cases on this. There's Noble Resources by the Shanghai Intermediate Court, then AQC and ARA by the Singapore High Court, and then BXT in the Singapore International Commercial Court. What's very interesting as well is these are the 3 seminal cases on expedited procedure. We've been participating in Working Group 2, whereby the states are looking at having a fast-track procedure under the UNCITRAL rules. So the SIAC experience with our 600 application and these 2 seminal Singapore decisions and then the decision from the Shanghai Intermediate Court are very relevant because these are the cases that things are kind of turning on. So that's our read of what happens when it's provided for a 3-member tribunal in the clause, but it's important to remember that we do have the discretion to appoint a 3-member tribunal under the expedited procedure, but in most every case, subject to a conditioned application, it will be a sole arbitrator under the expedited procedure.
Thanks, Kevin. Just looking at the time, we're about halfway through the session, and I'm going to invite at this time participants to submit their questions on the Q&A platform so we can deal with these at the end of or close to the end of the session. This is your opportunity to ask the SIAC Counsel any questions you have about what goes on inside the SIAC in relation to an expedited procedure. It's an invaluable opportunity, and please do take full advantage of it. I know Kevin and Jean are like, well, you know, thanks for that, Edmund. Now you're putting us on the spot. I'm sorry, you guys are on the spot. You're here. Let's move on to scrutiny. The previous panel was talking about scrutiny from the arbitrator's perspective. But what's scrutiny like from the perspective of the SIAC in terms of expedited procedure cases? Is scrutiny the same? How do you put expedited procedure cases in priority to the other cases because they need to be dealt with? Could you tell us a bit more about this? Maybe I'll start off with Jean and then go to Kevin.
So we actually apply the same standards as we undertake for scrutiny for normal awards. But we also factor in that 6 months timeline into the procedural timetable. So prior to the issuance of the procedural timetable, we typically remind the tribunal to let us have sufficient time for scrutiny so that we can receive the award in time. And following receipt of the draft, we will then remind them to submit their time spent and expenses incurred at least 4 days before the final deadline, because that's the amount of time that our accounts department actually need to generate the table of costs of arbitration to be inserted into the award. And during the scrutiny process, we will make sure that the procedural history captures any extensions of time granted by the registrar for the tribunal to make the final EP award.
Thanks, Jean. Kevin?
Yeah, Edmund, and I'm thinking about Jean because Jean, as counsel, I think perhaps has one of the most thorough scrutiny in the business. And as everyone would be aware, effectively, it's a 2-stage scrutiny whereby it first goes to counsel and then it goes to the registrar or me. And the process is very similar. It's just that we have to get these timelines done. So I can think of all sorts of examples where we might get an award just a few days before the expiration of the 6-month period. And that's why you really need to manage the case. And that's where SIAC's structured administration becomes invaluable, because Jean will have all sorts of dates in her Outlook calendar. So she knows when all of these expedited procedure cases are coming up on 6 months. And then at 5 months, maybe consulting with the tribunal, building in the time for scrutiny so that we can scrutinize the award, determine the cost, and then get it back to the tribunal. The one thing that we don't want to do at SIAC is be extending the time for the award to be rendered on the basis that our scrutiny process took a bit too long. I mean, I'm sure we'll be discussing the exceptional circumstances, but that would probably not constitute exceptional circumstances. So very similar to a situation whereby we scrutinize emergency arbitrator orders and awards. Those we might have to do overnight. I should also point out that the rules provide for an award in summary form. And that's kind of an interesting topic for academic discussion, because what is a summary form award? What I've noticed over, well, almost a decade at SIAC is that parties are giving fully reasoned awards. So unless the parties have agreed that reasons are not to be given, these expedited procedure awards are fully reasoned. And they may run over 100 pages on a relatively simple dispute. So the process is very similar precisely because the awards are quite similar.
Thanks, Kevin. Yes, let's get to this issue of the extension of time. Let's say there's an application for an extension of time to the SIAC. What are the registrar's considerations in extending time beyond the 6-month time limit for the award to come out? Kevin?
So we don't want to extend the time. We released a cost and duration study whereby it's shown that awards before a sole arbitrator or cases before a sole arbitrator takes up less than a year, around 14 months for a 3-member tribunal. So we take this 6-month deadline very seriously, but there is this relatively nebulous phrase of exceptional circumstances. And if you look at across all the sets of institutional rules, exceptional circumstances is defined almost nowhere. So we actually have to do the forensics on the case and see why is this extension being requested. So if for whatever reason SIAC, which I'm sure never happens, I can't think of it happening, if we somehow forgot that this award was due in 6 months, this would not be sufficient for an extension. If a tribunal said, hey, I'm quite busy, I'm just not able to get around to this right now, that's not also a case where we would not want to extend. But at the same time, if you're looking from a New York Convention standpoint, if the award is not rendered in 6 months, or if it is not extended, now the arbitral procedure has not been in accordance with the agreement of the parties. Those are the terms of the appointment of the tribunal, and that's what the parties have agreed to this expedited procedure as may be extended. The reasons for the extension that we see most often is because there's been a change to the procedural schedule. The parties perhaps want to have an extra round of submissions, and it could be that then the parties are putting it to the tribunal that we need more time, we've agreed that we're going to have this extra round of submissions, and then the tribunal will make an application to us. At the same time, when we're extending the timeline, and particularly if it's based on the agreement of the parties or the parties have amended the procedural schedule in consultation with the tribunal, we don't want to keep extending the time. So this is not a case where there will be, say, a 1-month extension granted, and then we're going to extend again and again. And part of the reason that we have an advantage, and I think that we have the most efficient tribunals in the world, is because we have the ad valorem system. Arbitrators are paid based on the amount in dispute, and they're subject to maximum caps. Under an hourly system, there could be a certain incentive for cases to keep dragging on, but it is in everyone's interest, the arbitrator, the institution, and the parties, to have these cases concluded as quickly as possible. So yes, there will be times when we have to extend the time, but very rarely, and we don't want to have multiple extensions.
Okay, I'm gonna pose a difficult question to you. Percentage-wise, out of all the expedited procedure cases that you're handling, how many, what percentage is extended?
Oh, I would be very cautious on this, and I'm already computing a lawyer's answer. What I would say is it's a very small, certainly single-digit percentage for when a case is extended outside the agreement of the parties. So a case where, for whatever reason, circumstances have come up. I can think, and this is the point of the session, is to give some good anecdotes. I can remember long ago, an arbitrator was requesting an extension on the basis of the transboundary haze. This arbitrator was not able to get to the award because the haze that year was quite bad. That would be an extension that we would be less inclined to grant. But it really is about the relationship with the tribunal and the institution. So Jean is going to be in consultation with this tribunal at an early stage to make sure that everything is set up for the award, the proceedings have been closed, and you have to start working with the tribunal early, because what we don't want is to be at 5 months, 29 days, and now we're dealing with an application for extension. And I think that was a very long answer that avoided me having to quantify a precise percentage, but it is quite low.
All right, thanks, Kevin. Let me get to the last question, which deals with taking cases off of the expedited procedure track. That's an option. I would imagine that's the exception, not the rule. But under what circumstances have EP cases, expedited procedure cases, been converted to normal track cases? Jean, would you like to tell us about this?
Thanks, Edmund. So in one of our cases, the tribunal was of the view that a respondent's application under Rule 5.4 to take the matter off the EP track should be allowed. So in this case, the tribunal actually noted that firstly, the original grounds for acceptance of the EP application had been ameliorated to a sufficient extent. Secondly, the new heads of claims introduced by the claimant, which could not have been anticipated from the claims as set out in its original notice, substantially changed the complexity of the claimant's case against the respondent, as it would require the appointment of experts to opine on the matter. Accordingly, the tribunal considered that it would be unfair for the respondent to have to appoint and instruct an expert within such a short period of time, possibly depriving the respondent of a fair and reasonable opportunity to present its case. Thirdly, the tribunal also rejected the claimant's argument that it complied with the criteria for Rule 5.1, as Rule 5.4 states that the tribunal may have regard to any further information as may subsequently become available when consulting with the registrar as to the continuance of the reference on the EP track. Yes.
Thanks, Jean. We have one question that's come in, which is quite interesting. I'm just going to read it out word for word. What is the SIAC solution? I always love it when they ask, what is the SIAC solution? If the arbitration clause sets 3 arbitrators, but the parties agree to the expedited procedure, should the SIAC request that the parties sign a written agreement for expedited procedure to prevent a future challenge? So basically, it's a mechanism to get around any challenge to the award on the basis that the parties haven't agreed to the expedited procedure expressly. Kevin or Jean, any thoughts on that?
I'll take a try at this. It would depend to a certain degree on, is the agreement on expedited procedure in the arbitration clause, or have the parties agreed post-dispute? And I think the question is also touching on if they haven't agreed on the number of arbitrators. So they've agreed to the expedited procedure, it's 3-member in the clause. Should the SIAC invite the parties to agree to a sole arbitrator? I know at least one other set of institutional rules where the institution will invite. The position under the SIAC rules and the position in Singapore is that the president does have that discretion. What we would do in that circumstance, if the parties have agreed and the agreement seems clear, whether in the clause or post-dispute, is that we'll be inviting comments in any event. So it could be the case that the parties might agree on a sole arbitrator, or that they will differ on whether it's a sole arbitrator or a 3-member. But this happens in institutional practice quite a bit. The parties could agree on a variation of the original arbitration agreement. So it says 3-member in the clause, we call for comments, and the parties say, yes, in addition to our agreement on expedited procedure, we also agree that this should be before a sole arbitrator. And then very easy for us to proceed. I should point out as well that even where there's party agreement, it still requires an application to be made to the president. The rationale behind that of not immediately channeling an agreement into the expedited procedure is that the sufficiency of the agreement might be at dispute. They could have tangentially agreed to a fast track proceeding, the language may be at issue, and then even an agreement may end up being contested. So just for further safety and to ensure the sanctity of the proceedings, we want to make sure that we get that president stamp of approval even when there's an agreement on expedited procedure.
Thanks very much, Kevin. We're about 2 minutes out from the end of the session. We have one final question. The words summary form trouble me. Has SIAC received awards in such a form? I suppose they have, but have they really been in summary, I think is what the question is asking. And can such awards, redacted of course, be made available to the members of the arbitration community on the SIAC resource website? In other words, can you give us some guidance as to what a summary form award would look like? Either of you.
Yeah, I'm not, so that's a great question, and it touches on what I was saying earlier, is that there is no definition of what a summary form award is. An award needs to be reasoned, or the parties have to agree that no reasons are to be given. And if it is a reasoned award, that means that it has to have certain elements within the award. It doesn't have to be well reasoned, but it needs to be reasoned. And that actually involves an important exercise of discretion on the part of the tribunal. You want to ensure the enforceability of the award, but you have to make sure all of the elements are covered. So where exactly are you going to start summarizing the award? Is it in the procedural history? Is it in the recitation of the party submissions, your legal analysis? Sometimes it doesn't seem like there's very good places to use that summary power. So it exists under the rules, but certainly when Jean is scrutinizing the award, any elements that are missing in the attempt to get to a summary form award will be pointed out, and we wouldn't be able to approve the award until all of those important elements were there within the award.
Thanks very much, Kevin. We've come to the end of the session. Unfortunately, and I think, but thankfully we've gone through all the questions that have been posed to us. It leaves me to thank Kevin and Jean for that very insightful session. And please stay tuned because I think we're going to take a break now. Sue-Ann's going to come on and tell us about the break, and then we're going to come back to the breakouts. Thank you.
Thanks, Edmund.
Thanks, Edmund.
Thank you all for that insightful discussion.